The last half of our panel, we have two other distinguished academics with us, and I'd like to introduce Professor Marcus Wagner, Associate Professor of Law at the University of Miami School of Law. He's an international law scholar. He previously taught at the Heidelberg Center para America Latina in Chile. He also served as an indigenous legal consultant for the Brussels office of the Wilmer Hale Law Firm. In 2006, Wagner served as a comparative and international law clerk at the Supreme Court of Israel in Jerusalem. In addition, he's legal counsel for the permanent mission of Germany to the United Nations in New York in 2003. Help me welcome him, please.
Thank you. Thank you for the kind introduction. Thank you for inviting me. And thank you to Barbette White, who at the last minute got me out of Miami when the fuel tank exploded. And otherwise I probably wouldn't be here. So I want to express my gratitude. And I'm not sure, as Daphne said, I'm not sure what my gift is, but I'll give it a try. And I'm also not sure why the two most junior people are the last people on the entire day. As was just mentioned, I was a clerk to President Barak, and had the pleasure to encounter him over a period of 5 to 6 months. In the summer of 2006, he tasked a group of clerks to compare the responsive legal system to the question of prison privatizations to get a comparative perspective on this. And it's hard, I think, to imagine that this type of exercise would have happened in a whole lot of other courts of that stature. I think of the US Supreme Court. The answer is clearly no. I think of the German Constitutional Court. It does its comparative analysis in a very different way. It either asks the Max Planck Institute, or it has the occasional foreign clerk. And I think one of your former colleagues, Melissa, who came from Idaho to Washington and Lee.
Oh, Russ Miller.
Russ Miller,
yeah,
exactly.
Yeah, sure.
But the Supreme Court of the US certainly wouldn't do it, I think, not in this way. And Justice Antonin Scalia noted in his dissent in Roper v. Texas that this court should not impose foreign moods, fads, or fashions on Americans. And I guess you can say that with respect to the Israeli legal system, I would have been guilty of exactly imposing some kind of, it would have actually been President Barak and not me, so I can always hide behind his broad back. So I think what we see, or what's nothing new, is that President Barak has historically made considerable use of foreign law. What I will not address, however, in my talk is whether the use of foreign law, at least not directly, is proper. And I see legitimate arguments on either side of that debate. Some, to me, seem more convincing than others. I will, however, say at the outset that contextualizing one's own legal system by reference to others and potentially uncovering unstated assumptions appears to me at least a valid form of challenging these assumptions. And I think I echo something that other speakers have said before. My remarks explore roughly the framework that some people call transjudicial communication, a concept also coined transnational judicial dialogue, and Melissa Waters here has written about this considerably. And I argue that the original conception of transnational judicial dialogue, developed for a very different purpose, can be helpful in this endeavor, but I want to add other elements, and you'll see in the course of my presentation what I mean by that. So what's the content of the original framework? The participants in this debate, mainly Anne-Marie Slaughter, distinguishes between 3 different types of communication: horizontal communication between domestic courts. We see this, for example, in the Canadian experience. The so-called Oakes test, I think, can clearly be traced to the German notion of Verhältnismäßigkeit or proportionality. The Israeli Supreme Court has used proportionality extensively, and as Lorraine Weinrib said, it's pervasive in many places around the world. Then there's communication between international and transnational judicial bodies on the one hand and domestic courts, and again the traditional examples are those, that are being cited between the Court of Justice, formerly the European Court of Justice, on the one hand and the EU member states on the other. Then there's this mixed vertical horizontal communication models in which the domestic courts talk through basically the international tribunals and talk with one another through an interlocutor. Slaughter refines her model, however, by outlining the different degrees to which courts engage with one another, either direct dialogue, a monologue, in which the originator may not be aware that its decision may have been picked up and used by another court. Again, we heard this before. Or intermediate dialogue, in which international or supranational courts or entities facilitate dialogue between domestic institutions. Now, what's the function of that type of exercise? Either the enhancement of the work of domestic courts is cited. I think more importantly is the function to disseminate ideas from one jurisdiction to another, be that jurisdiction domestic or international. A final one is what's being called cross-fertilization as the least formal one, since it doesn't require very much direction or targeting. Now, what can happen with all of this? I think Vicki Jackson put this in slightly different terms. What I'm saying now is a recipient of this type of communication is able to disregard the information entirely. I just don't take that information up. I can choose to absorb it without acknowledging it as a judge, or I can do so while making the source of the inspiration public. And again, there are advantages individually for each one of them and disadvantages. This very last mode of communication is also one that some people see as the most problematic in terms of comparative law, because it's viewed as an illegitimate use of non-domestic sources, particularly in the US, in decision-making processes that's supposed to be responsive to domestic polities. A final function is oftentimes cited as collective deliberation, a process in which a discourse over common problems takes place by various actors over a period of time. An example oftentimes cited is the European Court of Justice again and the European Court of Human Rights. And I think there's much less evidence of that in purely, at least overt evidence of that in purely horizontal relationships. Now, let me turn to something that I call either transnational judicial dialogue 2.0 or transnational legal discourse. And I like the second one better by now, transnational legal discourse, because I think if we want to look at the legacy of someone like President Barack, we need to take account of, yes, the judicial function that he had, but also in the way that he talked to other constituents internationally. I don't talk about domestic ones as much. That I think is fairly obvious. But there are other receptors, so to speak, that took up decisions, and I'll come to that. So number one, we had the open dialogue between domestic courts. Outside of Europe, where it's partially constitutionally mandated, and I speak of the European Union as a constitutional entity, where it's constitutionally mandated between domestic courts and the Court of Justice, the most prevalent form of transjudicial communication happens right there. And within Europe, a relatively recent study looked at the cross-citations between 10 European Supreme Courts, not constitutional courts, but Supreme Courts, tracking over 500,000 decisions, came to a number of conclusions that there are certain jurisdictions, and none of them are particularly surprising, that there are certain jurisdictions particular courts appear to prefer to borrow from. That's fairly, it's almost natural in some way. I think, Daphne, you alluded to this when you talk about language, right? So the Swiss Supreme Court and the Austrian Supreme Court cite to the German Supreme Court a lot. Interestingly enough, however, it's almost a one-way street. It doesn't go both ways, right? So then you can ask why that is, and whether one institution thinks more highly of itself or thinks it's more advanced. Certainly some of my Swiss colleagues always say, well, we're 15 years behind of the decisions of the German Supreme Court in civil cases. I'm not sure whether that's true, but I think it's an interesting observation. Also, that certain countries appear more part of the center rather than the periphery. So the French Cour de Cassation is part of the center with respect to some other countries, and the German Supreme Court, as I just alluded to, is also one of the more central figures in this regard. There's problems, of course, with empirical work like this that I'm not going to go into. But we see a similar development in a completely different field, namely when we talk about cross-reference in the context of anti-terrorist measures after 2001. We see that a fairly similar development and cross-references in Canada, the UK, for example, Israel, Germany, France, New Zealand, and of course, most famously, the Court of Justice in its Cadi decision. And I don't want to go into the details here, but I find this relatively unsurprising. Why do we see these cross-references directly after 2001? Number one, we see a common origin of all the security measures being implemented. This is Security Council Resolution 1373, which mandated that country put certain security measures in place. It's not surprising that shortly thereafter you see a whole range of decisions coming out in which citizens challenge these security measures on constitutional liberty grounds. And the courts have to interpret mostly a similar language and have to weigh these measures against fundamental principles of democracy and liberty, and therefore will, I think, almost inevitably look at the jurisprudence of courts and other countries. I say inevitably, fully aware of the US Supreme Court, and I say inevitably as someone who's received his education first and foremost in Germany, and for me, that's almost inevitable, right? The perception in the US may be very different. Now, let me come to an example from Israel. Comparative law played an overt role in the context of prison privatization. In late 2009, the court found that the privatization of prisons was indeed unconstitutional. The case was originally slated to be decided in 2006. While President Barak was still in office, the Knesset then decided to reconsider the question late in the summer of 2006 and made it impossible for him to participate in the actual decision. By a vote of 8-1, the Supreme Court decided that because of the profit motive of private contractors, the transfer of authority for prison management to a private contractor violated the constitutional principles of human rights and dignity. Now, there's a host of interesting questions, none of which I'm going to go into, but I'm just going to mention them. The exercise of inherent governmental function by entrusting them to private parties. Not much of a question here if you think about the prison context in most states. Second question, whether liberty and dignity are indeed the right hooks, legal hooks, for making these arguments, or whether there wasn't another way, I think, to reach the same conclusions rather than inventing a right against privatization. Whether, economically speaking, it's cheaper to house prisoners through private contractors, and if so, what non-economic costs are actually incurred, whether courts should decide the latter question to begin with, and to what extent the political process prevented judgment being rendered earlier. Now, different countries have found very different answers to these questions. This is somewhat reflected in the decision that came down in 2009. Let me just say this. If you read that decision, and I think it's somewhat surprising that the comparative research got somewhat short shrift. Having been involved in part of that research, I can tell you it was extensive. It also serves mostly, and I think I heard Lorraine, you say that before, it only serves in this particular instance to confirm the results already garnered in a previous mode of analysis. The decision focuses, with respect to comparative law, on the experience of the US and the UK in privatizing prisons and distinguishes the situation in Israel. And the decision encountered, I think rightly so, difficulty in finding partners to communicate with in other countries. Right? So you just don't have this. And let me just explain this. With respect to the situation in Germany and France, for example, that was such that the governments had rejected, mostly on constitutional grounds beforehand, that the privatization of prisons only allowed them to do this to an extent that made privatization unfeasible, i.e. the actual exercise of force had to be carried out by public officials. right? So, but those cases never made it to the Supreme Court or the Constitutional Court, could therefore never be referenced, or even in the court system sometimes, could therefore never be referenced. So sometimes we encounter this problem of not being able to communicate transjudicially because some of the cases never percolate through. And in the context of Germany and France, again, I think one can also say that the idea of handing over imprisonment, considered to be one of the core functions of governments with attendant political responsibility and democratic accountability, was contrary to the constitutional and political culture, at least in those two countries, and in many other countries, at least in Europe. And then to some extent, I think this explains the difficulty in finding cases outside of countries that have, historically speaking, had a longer track record of privatizing incarceration. However, I think this decision may actually be the starting point for transnational judicial dialogue, because it is the first decision that very clearly says prisons may not be privatized. So instead of taking it up, or only taking it up to a small extent, it may be the starting point on the Supreme Court level for transnational or for transjudicial communication. This decision is also, I think, a rare example of disapproving another jurisdiction. Here's another, the Supreme Court in Medellin. In the Medellin decision, the majority of the Supreme Court decided that the decisions of the ICJ are of a non-binding nature. Namely because international law does not require that states give direct effect to the decision of the ICJ, nor does constitutional law in the US do that. Now here's the disapproval. The German Constitutional Court said exactly the opposite, citing Sanchez Lamas and basically disparaging that particular decision. It's one of the very few examples where that, I think, openly happens, where you see a direct taking on of a different jurisdiction and saying and distinguishing oneself from that particular decision being made. There's a history to all of this that I'm not going to go into, but one of the cases that was brought before the ICJ was Legrand, and Legrand was a German national, and dealt with the exact same question, namely whether non-access to lawyers, or a particular set of lawyers, was contravention of the Vienna Convention on Consular Relations. There is, however, in the language, I think, another crucial element that I would like to point out, namely that the German court found that ICJ decisions were authoritative unless the German constitution demanded that a contrary solution was to be found, and the German Constitutional Court opted, in contradistinction to the US Supreme Court, for a relationship that calls for domestic intervention only in certain situations, namely in those situations in which a decision of the international adjudicatory body encroached upon core constitutional values. Just as a side note, this is the same type of argument the German Constitutional Court made in the so-called as long as line of decisions in the Maastricht decision, distinguishing that from the Maastricht decision. Now, the second type of communication takes place between domestic courts and international courts. Depending on one's point of view, the European examples are apt or not. I can go into that in the Q&A if you want to, but I can bring out the Sanchez Lamas decision again here. The dialogue started, like I said, years before, but with Legrand, Avena, and Medellin, and as Melissa Waters observed, in perhaps no other legal debate of recent years have the battle lines been drawn more starkly than in the controversy over US courts' engagement in transnational judicial dialogue with foreign courts. And I think that's right. I also think, though, that it's one of the very few line of cases where you actually have the same dialogue being able to happen, right? Because we don't see that line of cases happening all the time, where the same topical question is being thrown back and forth. And let me just remark that as a European, maybe, where the death penalty is on the table, right? That's, I think, another issue that's at place here. And so the Supreme Court rejects direct application again of similar to Medellin, but allows for respectful consideration of the opinion of the ICJ. Roberts then makes clear that the relationship between the ICJ and the Supreme Court is not one of subordination by the latter, but rather one in which the latter holds the upper hand, I think, in determining what effect a ruling of the ICJ may have as a matter of federal law. And then it's only logical that the Supreme Court found that the procedural default rule did somehow give full effect to Article 36 of the Vienna Convention. Roberts then provides an explanation for this finding in that procedural default rules generally take on greater importance in an adversary system such as ours, contrasting the US system from that of civil law countries where failure to raise a claim can potentially be remedied. Now, Melissa Waters considered this opinion as dialogical in an educational sense. And we talked about this before, so I can take a little bit of a stab and then I'll just withdraw right away again.
Stab away.
No. It's true that dialogue should not be unidirectional, but rather should be a two-way street, right? I just happen to think, and I think you think that as well ultimately, that in an ideal situation, this would actually be the case, a true dialogue that actually takes into consideration the ideas of the other side. This is, however, difficult, if not impossible, to achieve in these types of situations. I think one of the counterexamples may be the German Constitutional Court and in the context of the European integration. And I would certainly say that when human lives are at stake, as was the case in all of these decisions, one could envision a different handling and giving full effect to the obligations the US has entered into under the Vienna Convention. And I just cannot help but wonder about the underlying tone in Sanchez Lamas. It's one of, I think, condescension towards the International Court of Justice. This is the way we do it here, and if you don't understand that, let me explain that to you, right? And that just doesn't sound right to me. I will skip over the Israeli example because I think I'm going to run out of time and I want to get to another few points. But the example that I give in the paper is that of the line of cases surrounding the erection of a separation barrier between the West Bank and Israel. So Beit Zirik, the ICJ advisory opinion, and then Marabe, in which the International Court of Justice and the Supreme Court of Israel engaged one another in transjudicial communication. Now, the one thing that doesn't get mentioned very often, doesn't get mentioned in the context of transjudicial communication, and it shouldn't be, is a dialogue between courts and other institutions. And again, I can happily sort of come up with an example by President Barak. The decision on targeted killings was written in 2006 and taken up then by the Special Rapporteur of the United Nations with respect to targeted killings. And the court dealt with this issue, and I won't go into the details again because of shortage of time, but the Special Rapporteur on extrajudicial summary or arbitrary execution, Philip Alston, took this up. And the major point of criticism, without taking directly aim at the Supreme Court of Israel, I think that you see in that particular report of the UN, is that of how to classify a particular situation and therefore which set or sets of rules should apply. By labeling the conflict as one of an international character, the report argues, the international humanitarian law applicable in armed conflict arguably has more permissive rules for killing than does human rights law or a state's domestic law, and generally provides immunity to state armed forces. Because of the lower degree of procedural safeguards, the report continues, the potential for abuse is higher, and this criticism, it says, is applicable in the context of legal system in which executive power enjoys unfettered discretion and does not have to face judicial intervention. And I think here is where I would disagree with that particular report. The situation in Israel is very different, partially based, or actually mainly based on the jurisprudence of Aharon Barak. At least for the most part, I think it's fair to characterize that jurisprudence as saying law is everywhere, as Owen Fiss at one point wrote, that the executive does not enjoy unfettered discretion, even in situations where we in the US at this point would probably be much more deferential. And President Barak stipulated in this decision against Cicero that when the cannons roar that we especially need the law. And he also made very clear that black holes do not exist and that a careful balancing must take place even in those situations. Now, I'll just mention in passing that we often see semi-open dialogue, and we've talked about this a number of times now, so I'll skip over this. There are networks of judges that talk with one another outside of established realms. And the International Association of Refugee Law Judges may be cited as one of these examples. Another one is the Organization of Supreme Courts of the Americas, which regularly meet. Now there's also so-called non-open dialogue in which judges participate, or what I call non-open dialogue, in which judges communicate. And one of the examples that I can give is Judge Kirby, from the Australian Supreme Court, who simply says, well, look, we know one another, we communicate with one another, we call each other, we talk on the phone, and may exchange ideas by that. Again, I find that hard to criticize as such because judges are influenced in a whole variety of ways, and one of those ways may be the exchange of ideas with people from other places that occupy similar position and face similar challenges. In addition, academic teaching and scholarship is important in this context. And before I close, let me bring out one more or two more examples. Most of these modes of communication are part of a narrative, I think, that centers very much around the judicial function per se. And in many ways, the decisions rendered could be seen just as that, legal decisions with application to a particular case or a particular legal question around which numerous cases arise. The decisions surrounding the barrier/wall/fence may be a case in point. Great attention, I think, was paid not only in legal circles, but also in policy circles. And I think in that respect, judges sometimes take on a different role. And I think this was made clear by the Israeli government at one point that almost gave some kind of ambassadorial function to Aharon Barak through various statements. By way of conclusion, is what I've attempted to do is build upon and expand that framework of transjudicial communication and try to apply it to President Barak. There are obviously lacunae in this description. This kind of typology does not do justice to the often self-reinforcing elements and dynamics of international adjudication. As is true so often, but certainly is true here, I think the sum is certainly greater than its parts. And let me just close with a personal remark. In the summer of 2006, just as the war with Lebanon was beginning, President Barak called me into his office to discuss whether I wanted to continue my clerkship or not. He said, "You're free to leave." And I appreciated that, but ultimately decided and told him at that point that I wouldn't fly out. I just spoken to my father that morning, and he had told me, you know, you're old enough to know what you're doing. I relate that to President Barak, and he said, your father's a wise man. But he seemed concerned, right? He seemed genuinely concerned, and he said, Marcus, you're not Jewish. You're alone in Israel. You have no family. You have no friends. You have no protection. And then all of a sudden, everything changed in some ways, right? Because President Barak made himself my father and said, I'm your father. You have no family. I'm your father. Just stay outside the office. Some more importance here, but anytime you feel that you want to talk about anything, come in here. And I don't think that most people would tell me that I'm the most quiet person, but at that moment I could just only sort of make a hushed thank you. And outside of that, there was nothing more than that. What else would you say? Now, Judge Calabresi at one point said that wise parents do not hesitate to learn from their children. And it seems fitting to remember this quote from Judge Calabresi's concurrence in U.S. versus then. Not because of me right now, but not only did President Barak influence, I think, as even his critics note, other courts and judges around the world, but he was also influenced himself by a variety of sources, some of which stemmed from careful consideration of foreign sources and comparative law, as well as many other sources. Right? And in that way, he not only taught others, but also learned from others. I certainly learned a great deal from him during my clerkship, and always felt that when I left his chambers, and I don't say this about most of my former bosses, then when I left his chambers, I learned a lot in terms of like almost a mini seminar. And I hope that today I was somehow able to reciprocate, albeit in a very small way. Thank you.